Consistent with the law in most states today, the Model Penal Code requires conspirators to agree to commit a crime. An agreement to perform lawful conduct, even if it violates public morals or public policy, will not support a conspiracy charge. The Code's definition of conspiracy has a few components. First, the defendant must have the purpose of promoting or facilitating the commission of a crime. A mens rea of specific intent is required, meaning that the defendant must specifically intend both the conduct and the result elements of the crime. So if the defendant conspires to commit arson, and yet what results is robbery, the defendant can't be charged with conspiring to commit robbery. It follows that mere knowledge is never enough for conspiratorial liability under the Model Penal Code. In the case of a supplier of goods or services to a criminal operation, the supplier cannot be held liable without proof of purpose. In addition to having purpose, the defendant must agree with one or more people about the crime's commission. This can be achieved in two ways. The defendant can agree that one or more members of the group will commit the crime, attempt to commit the crime, or solicit someone else to commit the crime. Or alternatively, the defendant can agree to aid another member of the conspiracy in committing the crime, attempting to commit the crime, or soliciting someone else to commit the crime. You may recall from our earlier discussion that most states require an overt act in furtherance of the conspiracy in addition to an agreement. The Model Penal Code differs slightly in that it only requires an overt act if the target crime is relatively minor, such as a third-degree felony or a misdemeanor. In the case of a serious crime, such as a felony in the first or second degree, an overt act is not required. That said, because no overt act is required in the case of serious felonies, the Code insists that the evidence of agreement in those situations be concrete and unambiguous.